To in-house counsel and in-house legal professionals from all across North America and the world. Welcome to In-House Connect. My name is Shai Mahani. I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunch time with us, and special thanks to our wonderful sponsor, LegalOn, and our fantastic presenters today, Daniel Lewis, Noah Waisberg, and Professor Mark Lemley, who are going to teach us how to navigate AI risks in the business and with third parties. This is our 68th event of the year so far, and I'm wondering, is this your first IHC event, or have you tuned in to a webinar before? It looks like we have a 65-35 split, meaning 35% are new, so welcome. I hope you enjoy the program, and 65% are returning. So welcome back to the 65%. I hope you also enjoy the program. All right, today's program, Generative AI for In-House Counsel, Navigating AI Risks in the Business and with Third Parties. We have a rockstar panel today, starting with Daniel Lewis, who is the CEO of LegalOn Technologies. Daniel is a recognized leader in advancing legal technology with 10 plus years at the industry's cutting edge. He is the US CEO of LegalOn Technologies, a global leader in AI contract review, trusted by over 3,800 legal teams globally for pre-signature review. Our next panelist is Noah Waisberg. He's the CEO of Zuva. Noah is a leading legal technology and AI entrepreneur with deep experience in contract analysis. He is a co-founder and CEO of Zuva. Prior to leading Zuva's spinout, Noah was CEO of Kira Systems, which is the leading contract analysis company for professional services firm, from its founding to its sale to Litera in 2021. Before that, he was a corporate lawyer at Waisberg, and Noah is a NYU School of Law graduate and a member of the New York State Bar. And last but certainly not least, we are so lucky to have Professor Mark Lemley. Professor Lemley is the William H. Neukom Professor of Law at Stanford Law School and the director of the Stanford Program in Law, Science, and Technology. Professor Lemley teaches intellectual property, patent law, trademark law, antitrust, the law of robotics and AI, video game law, and remedies. His works have been cited over 300 times by courts and more than 40,000 times in books and academic articles, making him the most cited scholar in IP law and one of the 10 most cited legal scholars of all time. Mark is of counsel at Lex Lumina, where he litigates and counsels clients in IP, antitrust, and internet law. All right, rockstar panel. We are so fortunate to have Noah, Daniel, and Professor Lemley with us. So I will turn things over to Daniel to get us started.
Thank you, Shai. Thanks for that great introduction. Good morning, good afternoon, everybody. So over the last year in my work at LegalOn, I've had the opportunity to work firsthand with generative AI to transform legal work, specifically related to contract review, helping legal teams before they sign contracts. And during that time and through this work, I've been able to talk to hundreds of in-house lawyers who understand or believe that AI can transform how legal work and more than just legal work gets done. So it's in those conversations, it's become clear that in-house teams are at the front lines of navigating legal questions and how their companies train and use and protect against generative AI tools like OpenAI's ChatGPT. So that's why we put this webinar together today. A little bit more background about me. So I've spent the last 10 years building technology with AI to hopefully help advance the legal profession. I started in legal tech after graduating from law school, founding and leading a company called Ravel Law that helped pioneer the use of data analytics and visualization in research. After LexisNexis acquired Ravel, I oversaw several LexisNexis business units, including practical guidance and kind of all secondary and analytical content across the US, UK, and Canada. So that's the experience that I bring to this in terms of working with AI and working with content, working with authoritative, trustworthy content written by lawyers and thinking about the intersection of those two things. I'm excited today to be joined by Noah and Professor Lemley. Professor Lemley is my former professor from Stanford Law School, so it's a treasure to learn from him again today. And what Shai didn't mention about Noah is that Noah has literally written the book on AI for lawyers. So today we're going to be diving deep into the rapidly evolving legal issues around generative AI, model training, usage, and protecting intellectual property. So Mark and Noah, thank you for joining us. Let's jump right in. So today we're going to dive into the legal issues around generative AI. But before we do that, Noah, I would love if you could provide a brief overview of what generative AI is and how it differs from traditional AI, traditional machine learning.
Sure. Thanks, everyone, for joining us. And actually, Daniel, I've written 2 books. So not only the Wall Street Journal best-selling AI for Lawyers, but also Robbie the Robot Learns to Read, which I believe is the world's first children's book on machine learning. I suspect Mark kind of beats me out in the publications front, but
not when it comes to children's books. I'll cede that.
So you're talking about AI. The first thing is just what is artificial intelligence? This is actually something that people get into fights over. I don't really think it's a worthwhile thing to fight about. And so I tend to think about AI as just a piece of technology that's doing something that a human or animate intelligence would otherwise do. So if it's something that you use rules to get there, or you use really fancy computer programs to get there, it's all, when we started Kira Systems back in 2011, was you could either write rules to get it to work, or what we did, which is we would train models what to do. So for example, if you were trying to teach a computer system to find an assignment clause, you would have a lawyer highlight a bunch of assignment clauses, and the system would take that and it would learn from that. Generative AI, on the other hand, there still tends to be a feedback loop in a lot of the better systems, but it more is given vast amounts of content. Like, say, in the case of a lot of the systems that we'll be talking about today, they were trained literally by scraping the entire internet, more or less, and put into a database, and the systems just learn themselves. And it's actually very like human learning, if you think about it, in the sense that we just get huge amounts of data and we kind of make sense of it ourselves over time just by looking at lots of stuff. We figure out how the world works. So that's generative AI. And in fact, a lot of the time in systems today, you've got multiple forms of AI working. So for example, for contract review, we find a really good thing to do is to use these supervised learning models to find the right section of the contract, like the assignment clause, and then perhaps layer a generative model on top of it to figure out what that particular section, like assignment clause, means. Like, assignment requires consent, assignment requires notice, can't assign. So I think that's a really quick description of traditional versus generative AI. Mark,
Can I just throw in one thing, because I think it's going to turn out to be important, sort of both for the use of it in law and for the legal implications, right? Which is, as its name suggests, it is generative. That is, it is not a search engine that is finding existing things and handing them to you. It is making things up as it goes. It is doing so in a structured way based on what it has learned about the data, but it is in fact generating new and different things. And that's going to have, I think, some important implications as we go through.
Perfect. So let's move to the next slide. Just a quick overview of why should in-house legal teams care about generative AI within their legal department and their business. So we're going to get into plenty of the legal issues, but there's also kind of economic and productivity potential here that is quite staggering if you believe some of these estimates. So, Goldman Sachs estimates AI could boost GDP by 7 trillion annually. McKinsey estimates generative AI could boost GDP by several trillion annually. And it's becoming a priority across businesses, which we're encountering firsthand as well. Gartner has polled CEOs, finding that generative AI is being viewed as the top disruptive technology across industries. Another poll found that 55% of organizations are in pilot mode or in production mode with trying out new generative AI tools. And then there's specifically potentially vast use cases within legal. Goldman Sachs predicted AI could fully automate 44% of legal tasks. Whether you believe all of this stuff or not, I think it's directionally accurate, which there does feel like massive possibility here in transforming how some of our work gets done, taking specific tasks in legal that have been pain points for many, many years, honestly, for lots of folks, and now encountering a potential solution that can accelerate that work. So Noah, what's your take? Do you believe these estimates, or what's your mental framework for thinking about why we should care about generative AI?
I think overall we should care a fair bit about AI, and I think generative AI is part of that. I'm not sure if any of these specific numbers like Goldman predicts AI could fully automate 44% of legal tasks. Like, I suspect they did that as a top-down forecast, not necessarily thinking about, here is the day in the life of a big law lawyer or an in-house lawyer or a small law legal aid lawyer, and here's what they do. I suspect it was more, someone pretty under-rested kind of coming up with a number there. But I think overall, there are ways you can be made fast and more efficient. Just, for example, at my last business, Kira Systems, which most of the world's big law firms used for contract analysis, we found people were able to review contracts in like 50% less time-ish, a little bit more, a little bit less, and they were able to do the work maybe even more accurately in a lot of cases. So if you think about that, that's like pretty impactful, because corporate lawyers spend huge amounts of time doing contract review and due diligence. Similarly, they spend huge amounts of time negotiating contracts, and I'm sure Daniel could give us numbers about how LegalOn helps with accelerate that type of work. And when you think about things like negotiating contracts, which for some of you may be a main task that you do, going faster at that work can be really impactful. There's a ton of interesting things we could talk about, and I don't know if we will on this webinar, but I think any of us would be happy to some other time, around just what the impacts on the legal labor market are going to be of that. Like, if you can do work in half the time, does that mean you need half the lawyers? I actually think that's not going to be the case, but we'll see. I think we should keep cranking, but generally, overall, this technology has been making an impact in legal since probably 2015 or so, 2016. And I think there's real use cases where people are saving lots of time, they're doing more accurate work. And I think the new technology is pretty awesome and will help us do even more impactful stuff.
Let me just throw in a couple things there, Danielle. All right. So the first is, one question, and maybe the question of a most immediate impact to this audience is sort of, how does it change the behavior in my in-house practice? But I think one thing that is worth noting, and where it is likely to have quite a significant impact, is in broadening the provision of legal services. Right, the average person in this country would never occur to them to go talk to a lawyer. That's what rich people do, right? And so the idea that you could get a will, you could sort of incorporate a business, you could file a trademark, you could do sort of simple things very cheaply in an automated way, I think has the potential to transform a big part of legal practice, right? Though the changes at the high end of legal practice, I think, are going to be somewhat different. Even there, I think we're going to see real changes. So I, founded Lex Machina with Josh Walker a couple, almost 15 years ago now. But one of the things that we found as a result is not, we didn't automate patent law and get lawyers out of the equation, right? But what we did is turn it from a situation in which you were kind of relying on anecdata based on, I found some lawyers and they had this, they appeared in front of this judge once and this is what happened, right? And you gave people systematic knowledge and the ability to actually figure out, right? Is this argument going to work? What are the best places to file this case, right? How long will it take, and that sort of thing. And I think those are fundamental changes that affect legal practice. They're not changes that make all the jobs go away, right? But they will definitely change how you do those jobs. The other thing I will just note, you may think that you are not in fact using AI, but I suspect you are wrong. Anyone who works in a company that has any software coders, I guarantee you that your folks are using AI, whether you think they are or not, whether you have told them to or not, and that's going to have implications. And if you have lawyers who've joined in the last 5 years out of law school, and certainly lawyers who join in the future, they're going to come expecting that, running stuff through ChatGPT as a first draft is just what they're going to do.
Yeah, I'm sure we could have a whole nother webinar about how this is changing legal education, but let's not go down that rabbit hole for now because it's too deep. So we wanted to get a pulse from the audience here about a few poll questions. So take a moment to tell us, how do you feel about the use of generative AI across your organization? And there will be a separate question within legal. So think about this across your organization. Are you enthusiastic? Are you cautiously optimistic? Significantly concerned? Unsure? Or does this feel not applicable to you in your context? So 28% of you are enthusiastic. Another 61% are cautiously optimistic. So if my math is right, we're talking about 90% or so of folks are feeling generally positive about this. And I think those numbers are really staggering. And those are consistent with other polls that I've seen done across legal audiences. And what I think is quite unusual about it is that the sort of historic scarecrow we've had about lawyers being fearful of new technology turns out in this space and with this technology to be, I think, more of a hypothetical than a reality. So there's lots of reasons to be excited about this or cautiously optimistic, but let's keep going and look a little bit more closer at the legal audience in particular within legal departments. So how do you feel about the use of generative AI in your legal department? Are you enthusiastic? Are you cautiously optimistic? Is it good for somebody else but not good for you? Or is it great for you and maybe good for somebody else? So let's see what folks say to that one. Cool. So on first glance, as the data comes in, it's looking about the same, actually. So again, about 25% of folks are enthusiastic about the potential benefits. Another 60% or so are cautiously optimistic. And less than 10% are significantly concerned. Less than 10% are unsure and would like to learn more.
Got it. And Daniel, I have a couple of questions for the panel. First of all, somebody wants to know what's the name of the children's book Noah referenced before. Noah, can you let us know?
Yes, Robbie the Robot Learns to Read, though I don't know that you can find it too easily. Right now, we plan to do we did it in 2015, and we plan to do a reprint with maybe not a male robot, maybe a more gender-neutral named robot. So stay tuned on that.
Very excited to get a copy of that when the time is
Happily,
right.
happily we'll hook you up. It's like 256 words and a board book, so you should be able to make it through pretty quick.
Yeah, so that's good. So one more question, and then we'll turn to the poll. How does the panel deal with the hysteria around AI and the feeling that it will eventually be smarter than humans and will replace us, fueled by people like Elon Musk, rather than augment our tasks?
I for one welcome our new robot overlords. Seriously, I mean, I do think, right, I think there's it's a really remarkable situation where we have both sort of an enormous amount of hype, which I think is overblown, and an enormous amount of backlash, which I also think is overblown. I mean, these tools are transformative in many ways. I think they are kind of strange to us in many ways, and it's going to take some time to get used to them. I don't think they're going to take over the world. I'm not concerned about that. I'm more concerned Elon Musk is going to take over the world.
All right, let's keep going. We got one more question, so we're getting deeper and deeper into learning about how folks are feeling. So we've got a specific question about, if we can move to the next poll, the next slide here. All right. So within your legal departments, one of the most often kind of talked about opportunities is within contract review. So how do you feel about the use of AI that assists with contract review in your legal department as we try to pin down a very specific use case? Are you enthusiastic about possible benefits, cautiously optimistic, significantly concerned about the risks, and believe it shouldn't be used, or are you unsure and learning more?
And folks, I want to pose a question to the audience. If you are using AI to review your contracts or assist with your contracts, tell us in the chat. I'm curious to hear what the use cases are, and if you are finding them valuable. Does it add anything? Does it not? Is it overhyped? Tell us in the chat what you're doing and what you're seeing.
So great, we've already got 70% participation on this. We have 38% are enthusiastic, 46% are cautiously optimistic, 5% significantly concerned, 8% learning more. So again, very almost 90% are feeling generally positive about this. And that lines up with anecdotal comments I hear as well. One in-house attorney I spoke with said, we've been waiting for this kind of technology for years. It's so frustrating that it hasn't been around. So I think there's reason to be excited about it. So let's keep going. Now let's get into some of the meat of the matter. There are several legal questions and challenges in play right now around Gen AI. Mark, could you give us an overview of the intellectual property and contractual issues at play?
Sure. Yeah. So the sort of IP issues, the copyright issues fall into three basic buckets, which you can see here on the slide. The first, which is what pretty much all of the litigation that has happened so far is about, is whether it is copyright infringement to train a generative AI system. So AI systems, as Noah mentioned earlier, work by sort of learning from kind of truly massive data sets, right? The Stable Diffusion AI has 2 billion images it trained on. OpenAI and ChatGPT train on sort of even more than that in terms of kind of text documents. And this is how they learn the relationship between words, right? How to construct sentences that are grammatically correct, how often and how likely it is that certain words are going to appear in certain combinations and so forth. But virtually all of that is copyrighted material. And so we now got close to a dozen lawsuits that say some form of the same thing, which is somewhere in that 2 billion is one of my works. You trained on one of my works. That's an act of copyright infringement. And I wrote a paper called Fair Learning several years ago that argued that this was and in fact should be fair use. And I'll drop it in the chat. On the strength of that, I got hired by a couple of the defendants in these cases, and so I am actively involved in some of this litigation. We have one decision so far, that's the Anderson versus Stability AI case, which has not tackled yet the core issue of, is training fair use? Fair use is a defense in copyright law, so you can't raise it on a motion to dismiss, but is otherwise kind of lined up with the defendants pretty much across the board with some of the other sort of a little wilder theories about what might be problematic. So I think the key question on the training is whether it's going to be fair use to make these copies for internal use and then not share them with the world, right? And the sort of precedent here, I think, is actually pretty strongly in favor of finding it to be fair use in analogous contexts. The closest analogy to me is the Google book search case, right, where Google goes and scans 10 million books out of the Stanford library without the permission of the copyright owner, keeps a whole copy in its database, but doesn't show the world the books. It shows the world 4-line snippets. So I think if that's what's happening, probably that's fair use. Well, things are going to get more complicated when you start to get output that is substantially similar. I think Noah disagrees with me, and so I'm going to let him jump in.
Yeah, well, and I do this cautiously since you are much stronger than me in this area, and I expect to thoroughly get crushed here. But I'm a bit more skeptical that the companies are going to prevail across the board in these suits, and I think they kind of need to, which we'll go to in a sec. But I think like when I read the Google case, what I saw was the court really centering on the idea that the Google Books was good for authors, right? That by exposing small snippets of their books and their works to the world, they were kind of bringing attention to these works like Robbie the Robot that might not otherwise get noticed. And I think that you have to question how much that applies in the situation of large language models, where arguably a situation where I think people like Anderson would argue that their real problem with these systems is that they could replace them, that they're using their work to sort of take work away from them. So do you think it's a pretty, like, I agree that so far the cases have been haven't really touched on fair use, and haven't really come out in favor of the plaintiffs, but I would say it's pretty open how those cases are going to come out on fair use.
I mean, it's certainly right that the copyright owners. I will say the copyright owners in Authors Guild thought they were going to be hurt by this, right? They all filed a lawsuit. They all wanted to stop it, right? There's a sort of long history in copyrighted new technology of copyright owners trying desperately to prevent.
The sky is falling.
Any technology, the sky is falling, right? And you can go back to the phonograph record, which was going to destroy the sheet music industry, right? And again. And whenever they turn out not to succeed, they always end up profiting. But I take your point, right? That is the benefit to Google search is I can actually point you to a book. Now, if that book is out of print, which was mostly what got litigated in Google search, maybe they don't care. But I do think the case law distinguishes between I'm going to compete with you by copying your stuff in the output, right, which is not permissible. And I'm going to compete with you by using your stuff, reverse engineering it, say, in the Google versus Oracle case or in the video game cases, in order to make something that competes with you, but that is not itself copying your stuff. Courts have usually said that's okay. I think the one wild card here that we don't really know about is what does the licensing market develop to be? Right. I think these lawsuits are all filed at a time when there basically isn't a market to license any of this material. If in fact a market develops for licensing, I think that makes it harder to claim fair use, right? Because the copyright owner can now say, I would have gotten paid in this licensing market for allowing this use.
And you have cases like that, though. Like if you think about the Getty Images versus Stability one, which you may also be helping on, like, I think that is probably a harder. So just for everybody on here who hasn't looked at this, Getty Images is a huge database of stock photos, basically. And I think there's like 2 million stock photos or something like that on there. And Stability also copied all of Getty images as well as the descriptions. So it'd be like webinar with 3 panelists or something like that, and there'd be a photo of it, and they copied those descriptions and the images. So it's like a super good training set. I think Getty Images is in the business of licensing these images to people and would have probably been happy to license them to Stability AI, but Stability AI didn't ask, and they just took them and trained on them. And as opposed to Anderson, I would say Stability or Getty Images is pretty well represented by my old firm.
So no, I think a lot may depend on sort of at the time that the training happens, is there in fact a sort of licensing market, right, or a strong potential licensing market? And I know is right to say, right, that's going to differ from circumstance to circumstance, right? So I like to take examples in opposite extremes, right? My guess is, right, we'll see a music licensing market, for instance, right? There are, it's a concentrated enough industry. There's enough here, right, that we'll see that develop. It strikes me as extremely unlikely that there's going to be a sort of Reddit licensing market that ChatGPT is going to use, and everybody will get, a micropayment for their posts on Reddit, right? Images are somewhere in between, right? Getty is more likely to sort of license, although they had not had a licensing market at the time, right? But it seems, I think this is something that can change over time, right? One complication in the Stability case, right, is what Stability does is, and what a lot of these do is train on what's called common crawl, which are things put up on the internet with the robots.txt header set to yes, please index me and allow robots. Now that's not, it might or might not be a contractual license agreement, but I think one thing it means is that some of the Getty images are in the database, but the 80 million mentioned in the chat, right? A lot of those images are in fact behind a paywall, and those don't show up in the training data set. And so I think there's an opportunity right there for the Gettys of the world to say, we will give you access to the sort of full data set for a license fee, and the market may well move in that direction.
So one interesting thing that kind of you raised there is the sort of robots.txt versus license agreement of the websites. And we may be even covering this on a next site, but a lot of the sites in the common crawl have terms of use on them. And when you look at the terms of use, a lot of the terms of use, even though they may have the robots.txt set to yes, so that Google can index them and sort of put them into the search index, a lot of them have license terms that kind of restrict the type of thing that Stability did. And I think it'll be, I don't know that there's any cases, you may, Mark, but I don't know if there are any cases on the sort of robots.txt.
But no, that is our very next topic. Before we move on to it though, Mark, I know kind of in prior slides, you'd put down that these lawsuits pose an existential threat to these companies, but are likely to be unsuccessful. I was wondering if you could kind of quickly unpack both of those things. Why are they existential? Yeah. And why do you think in general they're kind of likely to fail? Yeah.
So we've been talking about the likelihood, likely unsuccessful. So I will note, right, just in addition, aside from this core issue, right, the cases involve sort of other, I think, more outlandish claims that, well, the model itself somehow has a copy of all of my work inside it. That's just not true as a technical matter, right? Or the model and everything the model creates is a derivative work, no matter how dissimilar it is. That's just not true as a legal matter. And the court in the Anderson case throws those things out. So I think the core issue is the one Noah and I have been talking about, right? Which is, we make these copies, is it fair use? So I think it is existential, at least for the sort of basic generative AI companies, right? Because we're talking about billions of things we're training on. You are not going to get a license to billions of things, right? And so either this is legal and you can do it, or it's not legal. And if it's not legal, right, existing training goes away, but I think it's the question of sort of whether you could try to come up with a lawful permission-based alternative turns out to be really hard. There are a bunch of computer scientists that have studied this question, right? Could we train a ChatGPT replacement based only on sort of public domain or quasi-public domain data? And the answer is, in some domains, it's not terrible. Software, if you count open source as public domain, and you probably shouldn't, but you could probably train on a bunch of open source software and do a decent job. Law actually is not a bad one if what you're trying to do is train a case law analysis, right?
Or contracts, actually, too.
Contracts, if you do it within your own.
Okay. No, but
company.
You could do it on Edgar, which has probably 3 million contracts in it.
Although it's not, I mean, those things are copyrighted.
I think
people might not assert the copyright, right? But they might. But it turns out for a lot of other things, right, including the basic, just sort of how do you communicate in the English language, right, that are based on writing, it does a terrible job. And imagine, right, so everything since 1928 is presumptively copyrighted, right? So imagine your ChatGPT answering a question as it would have been answered in 1927, and you'll get a sense of sort of what we might be up against. So I do think, for this model, at least, it is an existential threat.
The other scary thing we should add on the existential threat is just the scope of the damages. So if you're talking about, just going back to that Stability Getty Images case, then Getty Images has claimed 2 million infringements of registered copyright works, among other things. And so there's differences in damages if they're registered versus not registered. But if they're registered, Getty Images is asking for, it's more than this and it's more complicated, but say $150,000 per violation times 2 million violations, which is existential.
Absolutely. And even, I mean, I think they're obviously pushing, but the key number to focus on my end is the minimum, right? So if a statutory damages for a minimum is $750 per work, and if you got 2 million works found to be infringed, and this is just one plaintiff, right? I mean, that's $1.5 billion minimum in damages.
So it's like 4 billion, like there are like 2 billion or 4 billion things in these models.
Right, exactly, right. And so, right, exactly. This is not, right. And I think it's interesting. I mean, we may talk about this later. I mean, the logical solution in other industries has been, well, let's just create a compulsory license or a kind of group license. But I think the 2 billion problem is a real problem here, right? So take Stability AI, right? The company's worth $2 billion total. They trained on 2 billion images. Even if we said we're going to take half of the value of the whole company and allocate it to copyright license fees, everybody gets 50 cents. Right. And so I think people, when people have an idea of sort of like, oh, I just want to share in the profit, I want my piece of it, I don't think they have 50 cents in mind.
Yeah. So let's switch to the next slide here and talk through a bit. Mark, could you guide us? What are the issues around licensing and web scraping and terms of service? And are there jurisdictional differences here that folks in-house should be aware of?
Yeah, I mean, right. So we started to discuss this a bit with the sort of robots.txt header, right? So a lot of companies have terms of service that say, don't scrape us. A lot of companies that also engage in scraping themselves have terms of service that say, don't scrape us. Whether and to what extent those are enforceable is an interesting contract law question. But my guess is most courts right now are going to enforce them against a corporate entity who kind of does it repeatedly and is put on notice of it, right? Which is what we're talking about here, right? That said, right, I do think things get a little different, right? Where what I am doing is not going on your website with a login and scraping content from the website, right? But writing a spider that crawls through the open things you have let anyone access on the internet with the robots.txt header set to yes. All right, Noah's right that sort of people did that. Robots.txt is done with the sort of idea that, oh, the robot is probably going to be a search engine and they'll put me in my search results and that's good and I like that. I think one thing we might see develop is a more sophisticated robots.txt header that distinguishes between I'm happy to be crawled for this purpose, I'm not happy to be crawled for this purpose. I do think it is whether or not you've basically sort of allowed people to do it by setting robots.txt header to come crawl me. There are cases on this issue. They could go in different directions depending on circumstances. But as a sort of background fact, I think it makes it somewhat harder to say, hey, I shouldn't be. You've violated the Computer Fraud and Abuse Act, for instance. I think goes away at that point, right? My guess is a lot of folks are going to say, yeah, we're going to change our API. We're going to change our terms of service to say you can't come crawl us, or you can't come crawl us to use in a generative AI. One complication, I think, is that the companies are usually not actually themselves crawling the service, right? They're often using services like Common Crawl, which kind of do this for search and availability purposes, and then accessing that data. But yeah, my guess is in the United States, people will write terms of service, and most courts will enforce those terms of service. And so you might be able to sort of stop yourself from being crawled or trained on if you wanted to. Europe is an interesting difference, right? Because in different directions, they are much less likely to enforce the somewhere on my website as a document that I wrote that I would like to be a unilateral contract, but they're also somewhat more likely to regulate the behavior of the AI directly.
So at Zuva, we've been building software to pull data out of contracts for a long time. Right? I saw someone mention Cure Systems in the chat. That was like the company that we spun out of, and I was the CEO before. And so one thing that we have real like of doing is actually looking at real contracts and pulling out data from them. And so we decided to look at terms of service for 40 plus of the main websites that were mentioned in the Common Crawl. Like we found sites that contributed the most to the Common Crawl, and we pulled a bunch of them as well as some other ones that we were kind of interested in. And we looked at what their terms of service said. And so effectively there were a few, like there was like one of the 43 we looked at, macrumors.com, had no terms of use. There were like 5 of them that had no restriction on the things that you would need to do to sort of scrape and train a generative AI system. There were about 5, and there would be more if we did the thing right now, of places that explicitly restrict AI training. But the interesting thing is those places that explicitly restrict AI training generally have other restrictions as well. So if you think about like The Economist or the Financial Times, those ones explicitly prohibit AI training, but they also limit sort of use of the website to personal use only. They have business use, like commercial use possibilities, but that's a separate licensing regime, like not going on there. They have no commercial harvesting terms in their terms of use. And they also prohibit modifying or creating derivative works, which Mark is saying may not count, but it's something else. So they tend to have overlapping restrictions. And the commercial websites that were the main ones crawled, like tend to have things that said you couldn't do this. And most of those restrictions, our sense is, have been in place for a while. So even though these things may have been scraped 2 or 3 years ago, things like personal use only and no commercial harvesting probably have been there for a while, even if the explicit AI training things haven't been.
I will note one important difference for the conversation Noah and I had about copyright, which is there's a big difference between being sued for breach of the terms of service
totally.
and having to prove damages from it, and being sued under a copyright statute where the only question is whether the damages are in the billions or the trillions, right?
Yeah, agreed. So I think, again, still here, even if you got like a bunch of little people who are trying to claim 50 cents a pop or $1 a pop or $100,000 or maybe more than that for repeated violations, the numbers are really big. I think although
I do think you're going to have to show harm, right? And this to me is where the interesting thing happens, right? So, and that might actually take us to the sort of output side of things, right? Because, you know, if I'm training on 2 billion images, right, or 10 billion text documents, right, there's this kind of like sense, I think, that a bunch of the creators out there have that look, oh, it's mine and it's being sort of collaged or put into the output. But the reality of the situation is the impact of the vast majority of those on most outputs is zero.
Though I think you could make the argument, I think if you're the FT or the Economist or the New York Times, all of which have restrictions on, I think you can make the argument that like, we're happy to sell you this stuff, you just didn't pay.
So let's actually switch over to the output part of it. And
I think we could keep going on this for.
Oh, I know. We've got more ground to cover, so we're trying to get through it. Mark, as we hit this, and I'd love you to speak to it, maybe you could also weave in. So the other facet of terms of use is what are companies allowed to do with the user's provided data, right? If you could bring that piece along as well, like do terms of use to say, hey, we're allowed to do XYZ with your user created, user generated data. How does that play in?
You mean the AI companies, their own terms of use?
Or any company that's planning on incorporating generative AI tools or building new generative AI tools, right? Yeah.
Yeah, right. So, everybody would like this to prevent anyone else from sort of crawling or using their stuff, but they're not going to like it when sort of all of their users have somewhere on my page, hey, no, don't use me with AI. And this is, to me, this is part of the kind of the sort of moral panic around AI. All right, so on the output point, I think the key issue here is, right, the lawsuits are mostly about training because the vast majority of the time, the output is different. It is generative AI and it is generating a new thing. So this is, I went on the left is Sarah Anderson, who's the lead plaintiff in the Anderson versus Stability case. She does comics that kind of look like this. And I went and actually asked Stability AI to give me a Sarah Anderson comic. And what you have is the thing on the right, which doesn't look anything like it. It appears to be, I think, an effort to depict Sarah Anderson maybe reading in a comic format. But the reality of the situation is, right, you're not going to get, even if you ask specifically for Sarah Anderson comics, the vast majority of the time, you're not going to get similar. There are exceptions, right? And so I've been working with folks in the computer science department here at Stanford to sort of analyze, right, what are those exceptions? Why do they happen? There's a paper I've got, which I put in the chat, but they usually for three reasons, right? One is what we call the deduplication problem, right? So we train on a wide variety of images. And so in response to your query, right, we might sort of have learned from the 500 most similar image, but those 500 most similar images might in fact be 500 copies of the same picture, right? And if that's true, if we haven't properly deduplicated, then we might get images like the one you see over here, right, which is pretty clearly a pretty close facsimile of one of the pictures. It's not actually memorization or taking a particular picture. It is an image generated by saying, oh yeah, there are a bunch of pictures that meet this criterion that all turn out to be identical. Second way things happen, I think, are, and this is a harder problem, these are sort of, what do you do about deliberate efforts to prompt infringement? So in the paper, we ask ChatGPT, give us a children's story about kids who go to a wizarding school. It does not give you Harry Potter or anything similar to Harry Potter. But if you ask it, give me a children's story that begins, and you give it the first paragraph of the first Harry Potter book, it actually does a pretty good job of spitting out the next several pages of Harry Potter, right? Because it has correctly identified in a very precise way what you want and what you're looking for. And so the circumstances in which people are kind of essentially trying to get infringement to happen, I think are problematic as a copyright matter, right? And the real question is, who should we hold responsible for that? The third and hardest category, I think, are things where the AI correctly identifies something as a category that it should be able to sort of depict, but that category also turns out to be copyrighted. So here's Baby Yoda generated by Midjourney. You get a pretty good image of Baby Yoda because Midjourney has correctly recognized that Baby Yoda is a concept like cat or coffee cup that lots and lots of people talk about, identify, and tag, and it has a very specific set of visual depictions, and so it'll give you a very good Baby Yoda. And at that point, I think all you can really do is as an AI company is basically like hand intervene and try to say, all right, no Marvel stuff, right? Don't even ask me stuff about Star Wars, right? And so all of these, I think, unlike training, where I do think it's an existential threat, but it probably ought to be legal, these are circumstances where there probably is going to be a copyright infringement finding. One question is who's responsible for it. But I also think these are not going to be existential threats to the companies precisely because they are the rare exception. They are not the norm. The soccer players here, this is the result of Getty Images lawyers trying really, really hard to get the AI system to generate something that looked like one of the Getty images. And this is sort of the best they could do, right? There are some soccer players fighting over a ball, but they don't look the same. They're not in the same area. But we asked it to give us a Getty Images watermark, and so sure enough, it gives us a Getty Images watermark.
Okay, very interesting. So let's move to authors. Who owns the output of AI-generated work?
Right. So the current answer to that is nobody. And it's the fault of the guy here in A, the monkey. There's a Ninth Circuit decision called Naruto versus Slater. This is you probably might have seen the monkey selfie. This monkey basically picked up a camera and took a selfie, and it went viral. And the camera owner said, "Oh, I own the camera. I'm the copyright owner." And people for the ethical treatment of animals filed a lawsuit and said, "No, the monkey owns the copyright. The monkey's the copyright owner." And the Ninth Circuit said, "Only humans can be authors." Now, big asterisk, right? Only humans or corporations specifically identified as authors in the statute can be authors. But the Copyright Office, as a result, has said anything that's generated by the AI, not copyrightable, right? So the image in B, which was generated entirely by AI, it would clearly qualify for copyright protection if you'd painted it. Court says, no, not a copyright protectable. In C, which is a whole comic book where the human wrote the text and had the AI generate the images, the Copyright Office says, you can have the copyright in the text, but you don't get copyright in the images. And that turns out to be true even where you've kind of tried hard to sort of generate particular images. I think there might be some room for protectability in what we call prompt engineering, right? Sort of like working and refining your prompt to try to get it to create the thing you want. But the Copyright Office has been skeptical. And even if that turns out to be true, it's going to be a really narrow copyright. So I think one of the interesting things that we're facing is, at least unless the law changes, and it probably ought to, there are going to be more and more things out there in the world that are AI generated, that are quite creative, that are quite interesting, that people might value, but that nobody owns.
So what are continue that thread. What are the implications for copyright law if we move to the next slide as well?
Yeah, right. So so copyright law has this what we call the idea expression dichotomy. We don't protect ideas, we protect expression, the particular way you implement those ideas, right? So behind me this is a painting that my wife did. She's an artist, right? You don't get the idea of a sunset, you don't get sort of some of the basic things around the sunset, but the particular way you do the brushstrokes, the way you do color and that sort of thing, that's protectable. Generative AI flips that, right? I think because what used to be, the idea was, well, all right, the ideas will be free, but the expression's hard. That's the stuff that's hard to copy. That's what you get protection for, right? Now it turns out the expression's easy, right? And we won't protect it, right? It's AI. AI will generate it automatically for us. We won't protect it. We also won't protect the idea. If we're protecting anything at all, it's going to be this kind of like intermediate sort of how did I write the prompts? Even if we protect those, it's going to be really hard to figure out in many of these cases, right, whether there's copying. My image looks like your image. They were both generated by AI. Is that because I copied your prompts? Maybe. Is it because I independently came up with the same or similar prompts? Maybe. Is it because I wrote different prompts and still got the same result? Maybe. Right? Maybe I copied your prompts and I got a different result because of the random seed, right? And copyright law is always dependent on if the output looks sufficiently similar, we're pretty sure it was a copy. I think that's going to be harder in the AI world.
Awesome. So last slide essentially here of substance is we've talked a lot about some of the open areas and questions in the law. What does that mean for legal teams in-house? Should they be putting the brakes on usage of generative AI or not? Like, how do we tackle these questions? What practical takeaways do we have for in-house listeners? Noah, do you want to go first on this one?
Sure. So I think we raised a bunch of ideas here that the generative AI systems themselves, like if you are a generative AI provider, there may be trouble there. But I think for a lot of the people on here, you're not in a situation where you work at OpenAI or maybe even a Microsoft or a Google, one of those places. You're just at a place that would be a user of generative AI. Maybe you're also a place that's generating content. To the extent you don't feel like having your content included in a training set, you should check and see if you have terms of use. That's probably the best protection you can offer right now, and we'll just see how cases play out on that. In terms of actually using the generative AI from a legal side, I would probably track what's going on in these cases. I think there are weird situations where you could see liability flowing down. So one thing to end users, I think there's a lot of things that have to happen before that occurs. But I think one thing you can do yourself to protect yourself is not don't use generative AI, which I think is really cool tech and can really make a positive impact for you, but rather just look at the terms of use with your provider. Like, do they do things like provide you with an indemnification? Is there like limitation of liability? There's very standard contract language around what happens in cases of IP infringement, and if there's replacement of the IP or something that the vendor does in those situations. So look for those things. We actually did another study on this a few months ago and found that a lot of generative AI contracts, both at like the OpenAI level and at the level of applications that individual people were using, like Jasper or Casetext, that those user agreements didn't have a lot of things like indemnification and IP replacement. That's been changing recently. I think OpenAI just this week said they were going to indemnify some people. I think Microsoft has said they're going to indemnify some people. Adobe said they are. So I think there is a trend towards more indemnification. But you should, it definitely, when we looked at these, a lot of these contracts weren't there. And I think as an end user, you should really try to check and make sure that you have those very standard protections. And then the other thing is, I would recommend trying some of this stuff out. Like, not every system is the same. Not every system is going to be perfect. They're not going to take you 100% of the way. But even if they save you 20% of your time, 30% of your time, it just can allow you to do a lot. You can probably come up with something good to do with that time, whether it's spending more time reviewing other things or watching webinars with Mark, Daniel, and I.
Let me add two things. So we've mostly talked about copyright, but of course there are a bunch of other issues that fall into this, right? Because as I mentioned at the outset of the talk, right, this is generative AI. It is generating stuff. It is making stuff up, right? And sometimes it makes up things that aren't true. I suspect everybody on this webinar is familiar with the firm that got caught filing a brief that had some beautiful cases directly on point that ChatGPT made up. So that's an obvious risk. But I think there are other risks. I mean, ChatGPT, if you ask things like, what crimes has this person committed? Sometimes it'll tell you a good story that turns out not to be true. And it'll tell you a story that's written in the way that like a news story might be. It quotes sources that it makes up, quotes reputable sources from articles that might not exist, right? So all of that, I think, is sort of potential risk to think about. My CS co-authors and I have a paper talking about these problems, and I sort of put that in the chat as well. That doesn't mean I think you shouldn't use it, but I think it means you should think about what you use it for, and you should particularly be sort of cognizant of, if you're using it as a sort of fact generator, a source generator, you want to be particularly nervous, right? It is much more useful as a summarizer, a text identifier, right? Something that will clean up your writing and catch typos than that. Second thing to note, I do think the current generation of generative AI, right, is this sort of foundational generation. We have trained on all the text in the world, right? And so we know how to actually write English sentences and so forth. But I think the future, and for the legal departments, the most important future, right, is not let's use ChatGPT, right? The future generations are going to be more specific, more targeted. It's going to be, hey, big law firm, wouldn't you like to do a sort of fine-tuned data set of all the contracts you've ever written, right? Not all the contracts written in the world, some of which are terrible, some of which are irrelevant, but just the ones you've done. And then we'll generate some contracts from that. And I think those are going to create different issues. They may be sort of less prone to some problems, more prone to other problems. Noah, you want to jump in?
Well, I think there's really interesting legal ethics issues that we could go into around if a firm decides to do that. I'm not going to say which way it would come out, but I would say there are separate issues there. I think one other one, just to jump in right now, and then Mark will jump back. I would be, to the extent your organization is using AI in connection with generating code, I would look into that a little bit more, and I would just make sure there are settings that are a little bit more restrictive that you can use, where you're sort of a little bit tighter with not reusing code. But there are some especially thorny issues. Mark kind of pointed earlier to around training on open source code, and there's certain open source licenses that can sort of have some really bad implications. And if you are an organization that is writing code, you probably have really strong restrictions on which open source licenses you are allowed to sort of work with within your organization. Like, I know that's something we are very careful about, and I think most tech companies are. And I would worry a bit that some of the generative AI systems that have been trained on code and open source code could present special issues. So if you are an organization that's writing code, it would be a good idea just to check into what your devs are doing there.
Well,
and Mark, just to jump in on your point, I think that's exactly right. These sort of foundational models I see are now being augmented for professional use cases. So for example, in legal, that means thinking about how do you handle data in a way that's very secure and ephemeral so that customers can be certain that their data isn't going into training a generative model. And it also, I think, in our case, what we focused on is how do we incorporate additional authoritative, trustworthy content into that work so that the outputs are more reliable and authoritative. And you know that they didn't just come from word salad internet, but came from more trusted, authoritative content sources. Yeah. So maybe with that, we can switch gears a little bit and open it up to Q&A. I think we've got one more slide as well. So as folks get their questions in, or as Shai and Corey help us sift through the many, many questions that I know are out there, tell us one more time as we look forward, kind of what other topics would folks be interested in learning more about here? Use cases in-house, tips for creating Gen AI policies, legal ethics, demos, none of the above. Shai, so maybe with that, as that's up there, could you help guide us through some of the questions that are outstanding?
Yeah, so a couple of things. First of all, I just want to say thank you to Dan, Noah, and Professor Lemley for delivering a wonderful presentation. I'm seeing the results come in. And I also want to thank the audience for the tremendous participation that's been going on in the chat, a lot of really great comments and engagement. So there's really a ton of questions, and I'll try and get to as many as we can. We talked about this, or you talked about this presentation, but people are wondering, what is your opinion of with AI tools that replicate the voices of famous singers, as well as, for example, AI tools that generate deep fakes? The questioner says, I believe it's a challenge to copyright law. Is copyright well suited to deal with the problem? If not, how should we address the problem?
Yeah, it's a great and really hard problem. So there's you might have encountered during the sort of 2 days it was available a song that purported to be a collaboration between Drake and The Weeknd, which was actually a pretty good song, and it really did kind of sound like them. It doesn't fit neatly in copyright law because we didn't take any lyrics, we didn't take any notes, right? None of it actually is Drake or The Weeknd. Maybe it's a trademark problem. I'm telling you that it's them when it's not, but what it probably is a right of publicity problem. And I think that's the same thing might turn out to be true of deepfakes, although some of the deepfakes also end up kind of working from original copyrighted material. But it's a real problem because I think we are conditioned as human beings to sort of believe what we see, and we're going to have to get over that. And we're going to have to get over it before the next election, among other things, right? Because there are already, the DeSantis campaign's already run deep fake ads showing Trump kissing Fauci and various other things. They're going to get better. They're going to get harder to detect. I do think the right way to think about that is probably the right of publicity, right? You're depicting me, you're misrepresenting, making it look like I have done a thing, endorsed a thing, etc. Probably existing right of publicity law, which is state law, could take care of it, although I know there are bills kicking around Congress right now that would sort of target this problem specifically at the federal level.
And those are totally going to get passed, Mark.
Well, because I mean,
because Congress is
completely functional. Yeah. Right.
Awesome. Next question, the writer's strike, right? The SAG-AFTRA strike, which just, I guess, resolved. At the core of that strike was the use of AI's use of copyrighted material. And the questioner is wondering, what do you think the future of AI and copyrighted materials is? Is there going to be a new part of copyright law to tackle this? Noah's shifting uncomfortably in his seat. What do you think, Noah?
Well, I think this comes, Mark is probably more expert on this, but I think this comes back to an issue that Mark and I were talking about an hour or so ago, right? With the Google Books case. And you can see clearly why the screenwriters were so worked up about AI, right? Because there's an incentive for someone like Netflix, who has a ton of content that they've created themselves, to go and train on all these scripts. And then you could totally drop the cost of production because you could just have AI trained on lots of scripts create content instead of hiring screenwriters. And so if you're a screenwriter, I think that would be a fear-inducing thing. I'm not sure how this is going to come out. I think the cases that we spoke about, I think in this case, to the extent Netflix had the copyright and like Netflix might be in a position where they could do this. And I think this is why the screenwriters felt like it was so important to get something in their contract, because if the contract says Netflix can't do it, then Netflix isn't going to do it, or whoever.
Yeah, and there's a parallel issue with the actors, right? Where I think what they're worried about is you're going to take my existing work, you're going to use it to sort of generate digital versions of me after I die or when I don't sign on for the sequel or anything else, right? And I think that's also being negotiated. So the thing I'll note here, right, is so that might be for the actors, it might be a publicity problem. I don't think for the script, right? I don't think for the screenwriters, it's a copyright problem. I don't even think it's a training problem because they've got lawful access to all those scripts, right? The output is not substantially similar. So it really, I think, becomes a sort of bargaining and a contract question, right? And so one of the reasons they wanted to fight about this and not have it happen, right, was because I don't think they have a sort of legal right to prevent you from using an AI to generate scripts as a matter of copyright law. But if we can get it written into the contract that you won't do it, then we're sort of preventing that form of competition. I think we're going to see something, by the way, very similar in the video game world, maybe even more so, right? There's so much right there that is coded, right? Anything, from scores to
but Mark, wouldn't you then say, so say Netflix writes a show using AI, in theory that script is not copyrighted, right?
Yep.
I think one super interesting spot we're going to see a lot of lawsuits is, that I don't think we've seen any yet, is places that rely on sort of vague terms of use to generate their training data. So I've heard this accusation with Adobe, where Adobe sort of theoretically has a permission data set that they trained their Firefly generative AI on. But actually, when you look at what the permissioning was kind of like pretty weak, right? Around, I think from what I read of it, that it was kind of like, you can use our data to sell commercially or something like that. And I don't know that the authors in question ever sort of anticipated this future use. And I think we'll see, I've heard even of a couple of legal tech companies who may have done this with some of the data put into their systems under similarly kind of vague use to improve the product type language. I'm not sure if those rumors are true, but I think there's been a lot of companies that have trained generative AI systems on private data, but whether they had the permission to train on that private data, which comes to the thing Mark and I were talking about before with like, can a law firm train on all their contracts? I think that is a growth area for lawsuits.
Yeah, and of course, the answer is 3 years ago, no one thought about this at all. And so any contract you wrote back then, you might interpret it to cover it, but no one, we didn't, it's not that we made a deliberate decision to do it. So one thing I think people are going to have to do is sort of think about whether we can do it, whether people will put up with it and write the contracts that are clearer in the future. Yeah.
Mark, do you have guidance for folks about when does the mix of human labor and AI create something that's copyrightable? So if AI drafts a first draft, but you then heavily edit it, or you edit just one sentence, like how do you draw a line there? What does that look like?
Yeah, I mean, so what the Copyright Office says right now, and what they say is not determinative as a matter of copyright law, but what they say right now is you get the stuff the human contributed, but not the stuff the AI contributed. I don't think this is sustainable in the long run. I just don't think it, right, that's not how the world is going to work, right? And my guess is, right, the first time that, right, I just straight out copy a Netflix screenplay and say, hey, yep, I'm free to do this, right? It's going to be a lot of pressure to change the law, but yeah, and I'm not sure it makes a lot of sense, honestly. I think the best you could say for this position is, we have copyright to encourage creativity. The AI doesn't need the money, right? It's not doing this for the money. But, a lot of the corporations that are employing it are, of course, doing it on the assumption that they'll be able to sort of own the resulting outputs. And some of them are going to be in for a rude shock.
Wow. This has been the most exciting Q&A session I think I've ever been a part of, and I've been a part of a ton. So one more question, and then we will wrap up. We can really go on all day, but somebody is wondering, what are the best resources, courses, certifications for attorneys that want to become specialists or experts in AI or generative AI? No one wants to give up their secret.
Well, I think a first step on generative AI is you really got to try ChatGPT. Like, it's amazing the number of people who haven't tried it at all, but it really is worth trying ChatGPT and some of the image generation type sites just to see what they can do. Like, look at outputs, but just go in there yourself and try it out. Like, as Daniel and I have been mentioning, there's lots of applications that incorporate this stuff. And I think you should try those applications too, but like as a first step, just try it yourself. I will say, just to toot my own horn here, that the AI for Lawyers book, which is readily available on Amazon and wherever fine books are sold, is a pretty good introduction to AI for lawyers overall. Some of the specific stuff on contract review and e-discovery, it was published in 2021. So some of that stuff has changed a lot with generative AI, but if you're just trying to figure out and get a rough sense of what some of the implications on work are and legal ethics issues and how this might play out for lawyers, I think it's a pretty good introduction. That said, if you're trying to go into like the copyright law issues and stuff, I think a lot of the stuff is developing, but maybe Mark or Daniel have some ideas there. Oh, the rename the book is AI for Lawyers.
Awesome. Daniel, did you want to say anything?
I think as you can tell from this conversation, there's still in some ways, a lot more questions than answers. So you're not necessarily going to find definitive guidance out there. I think this space is changing so rapidly that signing up for various AI newsletters, tracking the work of smart people in this space like Mark and Noah, I'm not sure there's a better way at the moment besides, firsthand experience like Noah's recommending, so that you're not judging from afar. You sort of have experiential learning yourself, and then staying abreast of the latest developments. But from a legal perspective, things are continuing to develop. And from the capabilities perspective and what can be done, every month there's something new. So anybody who's interested in this space, there's not going to be any rest for you, unfortunately, for the next few years.
The response from outside counsel that inside counsel most hate to hear is, that's an interesting question. But I fear that's the right answer here. It's an interesting question.
One other thing to keep in mind, like, there's so much happening here, and I hear from a lot of people that it's almost overwhelming how much is happening, how fast stuff is changing. But actually, I think if you kind of abstract a level higher, like, there's technology, it's new, it's pretty cool, it keeps developing, but like the core things, if you just pay attention to like, what are problems that I'm trying to solve? Like, maybe that problem is writing an email or writing a memo. And just think about those problems that you're trying to solve, and think about, are there tools that can help me solve those problems? And just don't panic with everything going on, but just stay calm and think about what you're trying to do. You'll be well served in this area. And just try to read people. Some of them will be bullshitters. So I don't know if that's okay. Some of them will be actually know their stuff. Just try to, I think picking out the bullshit from the real is kind of going to be an increasingly important skill set in this era where, as Mark says, you may have like election deepfakes and all that kind of stuff. I think we're all going to have to get a lot better at that, and just keep practicing. The same skills and being skeptical that you use in your everyday life will serve you well here.
And Nicole chimed in the chat with a great recommendation. Talk to your engineers about how they're using AI. That will also talk to the business generally, right? That's what in-house counsel should be doing. So talk to the engineers and pick their brains. So thank you, Nicole, and thank you everybody for wonderful participation. The chat was active like the whole entire time, which was awesome. Daniel, I'm wondering, we're going to wrap up, but before we do, tell us about LegalOn Technologies. Are you using AI? What is LegalOn Technologies?
Yeah, so LegalOn focuses on helping in-house teams with pre-signature contract review. So the run the business routine contracts that are taking up an overwhelming amount of time in most organizations, not just NDAs, but SaaS agreements, MSAs, office leases, venue rentals, all of that. So our product lets you bring a contract into the system, review it using software that will spot issues like, hey, this contract is missing key language, or this provision should be strengthened because it's not advantageous to you, or here's something that's in the contract that should be deleted. And then we provide you with software that lets you make a fix to that really quickly. So we'll spot an issue, we'll provide you with suggested language that's written by our own in-house team of attorneys, saying, here's why this matters, and here's language you can use to fix it. And then we use AI to let you click a button and make some red lines to that contract to effectuate the fix. So that's what we do. We serve almost 4,000 customers now globally across Japan and the United States, working with in-house teams of all sizes. Could be a solo GC all the way up to very large enterprises.
Awesome. And almost 38% of our respondents say they would be interested in live product demos of AI tools. So maybe we'll bring, a LegalOn demo to the masses. Noah, tell us about Zuva.
So Zuva is spun out of Kira Systems. So Kira Systems was a tool that a lot of large law firms use to do contract review projects like due diligence. Zuva is a little bit more focused than that. So it's the underlying technology of Kira. And so for all of you as in-house lawyers, the thing to think about is if you have a legal issue that you're trying to think about, like an event of force majeure, a hurricane just hit, and I got to look at all my contracts for force majeure, or I have a whole bunch of leases and I'd like to create abstracts. We have lots of websites where you can go, you can upload your contracts to those websites and get results for free almost right away. Now, if you feel like exporting the results, you got to pay us some money, but not too much, very reasonable. And you could, for example, right now, like this second, go to leaselens.ai, upload a lease and get results in the next couple minutes in an abstract form. If you feel like exporting it, you'll have to pay a bit, but you don't need to. And it's there for you. So we can do the same thing for you with if you've got an M&A transaction going on, if you're trying to find exclusivity in your contracts, we can find tons of stuff, and we just try to make it dead easy to use our tech.
Awesome. Thank you. That's what my wife says when I ask her how much did she spend, at Saks. She says, don't worry, it was very reasonable. But I'm sure you're right.
No, I can tell you. So if you feel like a lease abstract, it's going to be $25. You can get it if you feel like a download, but you can literally use it for free and not pay us anything. And tons of people who come to our sites use our stuff for free. We don't harvest your contracts, and it doesn't cost that much. If you're trying to do a normal contract, not a lease, it's like $10, which is pennies compared to what you'd spend on a large law firm reviewing for this stuff.
Well, put that link in the chat. We'll wrap up. I guess, Professor, do you have any final words for our audience before we wrap up for the day?
No, I think these are going to be, issues everybody's going to have to face, and we're just at the beginning. So stay tuned.
All right. Daniel, any last remarks before we sign off?
Nope. Thanks, Shai. Thanks to all of our attendees. I hope you had as good a time as we all did talking about this stuff.
Awesome. And last but certainly not least, Noah.
Thanks so much for joining us. I had a really fun conversation. I think we could all talk about this stuff for hours and hours. This is a spectacular time to be a lawyer, right? There's just so many things that the way that I got into legal automation is I spent tons of time as a junior lawyer doing work that I hated, that I wasn't that good at, that seemed really repetitive. And if you like doing work that makes you think, this is a time when you're increasingly able to spend your time on work that makes you think. And I would just embrace the moment.
I love it. We'll end it there. Embrace the moment, right? Carpe the moment. So thank you for tuning in. This was a wonderful program. Thank you, Daniel, Noah, and Professor Lemley for giving us an hour and change of your time. It's wonderful. Thank you, everybody, for tuning in.